speakers, global challenges to freedom of expression. And so this panel, we have a range of international experts to discuss priority issues on the global free speech agenda, namely the deterioration of our ecosystems and the environment, the rising threat to democratic systems of government through the undermining of electoral processes and bad actors and authoritarian forces, the use of artificial intelligence to spread disinformation, and the abuse of legal systems by powerful business and political interests through frivolous litigation against those who speak out on issues of public interest. Our moderator, Sandra Coliver, is one of our founding supporters and has worked on many of these issues throughout her career. She is the former Senior Legal Officer for Freedom of Information and Expression at the Open Society Justice Initiative. Previously, she managed or participated in human rights and rule of law programs around the world, including with the UN High Commissioner for Human Rights, the OSCE, and Article 19. She also coordinated the drafting of the Trionfi Principles on National Security and Right to Information, and helped develop the Johannesburg Principles on National Security, Freedom of Expression, and Access to Information. So thank you so much, Sandy, for being here, and the floor is yours.
Well, Holly, thank you. And is Nikolaus Forgo here?
Yes, he is on. He is on Zoom.
Okay, okay.
Can you see and hear me? Yeah, can you see and hear me?
Nikolaus,
Yeah,
pleased
okay,
to meet you.
good.
Now I can see you.
Nice to meet you. Okay, wonderful. Here I am.
Very pleased. Well, it's an honor and a delight to be with everybody and to see so many friends, and to be on the podium with such distinguished experts. And it's very edifying to follow the last beautiful panel that reminds us about the power and the courage of writing effectively and forcefully in exposing truth. So this panel is addressed to the critical legal frontiers in freedom of expression. We have 5 experts addressing 4 topics. The first, we had planned to have 2 experts to address SLAPS, the first topic, that's strategic lawsuits against public participation. The one speaker who is not able to participate is Alex Papachristou of the Vance Center. He sent a message explaining his regret, and I will just read it to you. My conscience does not permit me to participate while the host institution has arrested, suspended, or otherwise suppressed the free expression of its students. Protesting peacefully matters of clear public concern. I regret the inconvenience to those attending and intend no criticism of individual decisions to join. I hope to meet everyone in different circumstances and otherwise remain in solidarity in protecting and promoting free expression. If people would like to be in touch directly with Alex, please feel free to be in touch with me or Holly. We can put you in touch. And I think we share some of those sentiments, but also share the conviction that uniting together to strategize on ways to defend free expression is called for at this moment more than ever. Speaking on SLAPS will be Caroline James, based in Johannesburg. She has been the advocacy coordinator at AmaBhungane Center for Investigative Journalism since 2022. She previously worked as a lawyer with Corruption Watch and with the Southern Africa Litigation Center. I'll continue and introduce all the speakers, and then we'll jump right in. We have 2 experts who are discussing the environment in journalism. We'll start with Barbara Trionfi. She has worked for more than 20 years with the IPI, International Press Institute, based in Vienna. 8 of those years as executive director. The IPI is a global network of editors, media executives, and leading journalists. She has taught a range of media courses and now focuses her research on climate and environmental journalism. You can find links to her recent publications under the speaker's bios section of the website. Jorge Calderón Gamboa is an independent expert for the UN Harmony with Nature program. which was established by a General Assembly resolution and is an office under the Secretary General. And he is also with the Mishi, the independent mechanism for compliance of the IDB, the International Development Banks. The Mishi addresses environmental and social grievances of communities potentially affected by the IDB group's operations. Previously, he was a senior attorney at the Inter-American Court of Human Rights, where he led many of the cases regarding indigenous and other vulnerable groups, rights of economic, social, cultural issues, and rights of the environment. He also served as a senior clerk at the Mexico Supreme Court and as a seconded jurist at the European Court of Human Rights. Next, we have Mishi Choudhary, who will discuss elections and free expression. She is a technology lawyer who has litigated precedent-setting cases in India and New York to protect online free speech and privacy, and in India in particular to challenge surveillance. Since 2022, she has served as Senior VP and General Counsel at Virtru, a company that offers easy email encryption. Previously, she founded the Software Freedom Law Center, a legal services organization based in New Delhi that brings together hundreds of pro bono lawyers, policy analysts, technologists, and students to protect freedom in the digital world. Finally, with us virtually is Professor Nikolaus Forgo. He will talk about AI and free expression. Nikolaus heads the Department of Innovation and Digitalization in Law at the University of Vienna. He has been a member of numerous boards and policy committees, including the AI Advisory Board and the Data Protection Council of the Republic of Austria. He has taught IT and IP law at the University of Vienna, as well as at Leibniz University in Hanover. So, Carolyn, we will start off with you talking about SLAPP lawsuits.
Thanks very much, Sandy. I certainly don't want to pretend to be an expert in SLAPPs generally. My expertise has come from South Africa and the engagement that I've had through my work with SLAPPs there and the responses to it. But I think that the development of the law in South Africa is quite relevant and representative of developments around the world. And so I hope in that respect it will still be relevant to non-South African lawyers as well. So, as Sandy said, the SLAPPs stand for Strategic Lawsuits Against Public Prosecution. No, public participation. And they're essentially cases that are brought against journalists and activists in an attempt to silence them. We've heard of examples that Paul was talking about, his mother and the number of cases that she faced. And in South Africa, the recognition of a SLAPP offence is quite recent. It was only in 2022 that the Constitutional Court recognized that it can be raised as a defence in defamation cases. But disappointingly, in that case, they found that the conditions required to bring a SLAPP offence weren't present. So although finding that in principle, journalists and activists can raise that as an offence, the activists involved in that case were not able to and had to go back to the High Court and restart the case, which is representative of how challenging SLAPP cases are, because part of the problem is just the costs involved and the time involved, and having worked their way all the way to the Constitutional Court to then be returned back to the High Court just elongated that. But I think what has been so interesting since that period and since that judgment is how some of the lower courts have applied the concept of a SLAPP offence in South Africa. So that first case was a relatively typical one. It was a series of defamation cases involving huge amounts of money brought against environmental activists by a very powerful and rich Australian mining company. And that follows the trend of most SLAPP cases around the world. But since then, there was a sort of trilogy of cases in the middle of last year where the High Court judges extended that to non-defamation cases. And the first case that I want to sort of talk about was a private prosecution that had been brought against a journalist by our former president. And the case was involving, the the private prosecution alleged that the journalist had unlawfully published private medical information. It was quite clear that there was no merit in that. The information came from publicly accessible and already filed court papers. And in one of the judgments sort of dismissing the ability for the prosecution to go ahead, the judge referred to the concept of slaps and said that an abusive process through the criminal private prosecution does constitute a slap, and that it is possible for the victim of that to raise that as a defense. The second one, which we will hear more about later tonight, is a case that my organization was involved in, and it involved an ex parte gagging order that had been obtained against the media institution. And there the focus was that the element of the sort of slap was that the case had been obtained, or an order ordering the gagging and the return of documents had been obtained ex parte on an urgent basis and in camera, all of which was an abusive process. And the judge was able to dismiss and overturn the sort of original order, but again relying on the jurisprudence of slap law and the abuse that involves. And then the final one was a slightly more typical and more traditional one, but it was in response to an urgent interdict that some powerful businessmen were seeking to prevent the use of a pejorative term by a specific media house. This was a term that was widely in use around the country by ordinary people, by every sort of journalist that referred to these businessmen, but it was very clearly a targeted attack at this specific media house. And again, there the court applied slaps. And so I think it's really interesting that when we're talking about sort of the judicial role in protecting freedom of expression, that here there were three judges who really took an established legal principle that is growing around the world and has a sort of a footprint, but creatively applied it to circumstances that were unique to the realities that they face. And I think that that's quite representative of the need to sort of take things forward. But what those cases also demonstrate is that slaps continue to happen and they continue to be very disruptive, and that we can't only rely on judicial intervention. It's too precarious. You kind of are reliant on getting a good judge, and if you don't, things will not turn out the same way. But also, it's often too late, and journalists and activists have already had to incur multiple financial burdens, the complete disruption of their work, which is something we certainly experienced when we were fighting it. And so there needs to be some other ways to approach it. And I think, as you sort of heard, the development of anti-slap legislation with the EU Daphne's Law Declaration and the way in which that is becoming more accepted is really important. In South Africa, there is a model anti-slap piece of legislation that's been drafted by civil society groups, which will hopefully move forward. But then I also think it's important to note the other development, which is in the UK with the Solicitors Regulation Authority, where that regulatory body has put their members on notice that if they continue to represent clients in slap suits, they face censure. And I think that that's a very, very key element, because it starts nipping them in the bud before we actually get to court, before the huge legal bills start sort of piling up. So I think I'll stop there. But
well, thanks, Caroline. And picking up on your point about the huge legal costs, Alex, if he had been here, would have talked to us about Reporters' Shield, which you may have heard about is a project to provide insurance for NGOs and nonprofit media that are engaged in investigative journalism to cover the costs of media defense. I also want to give a shout out to Global Freedom of Expression Database. I Googled or searched keyword for slap and found 35 cases. Of those, most are from the last 3 years. And you get quite an interesting survey that there are positive decisions from 9 countries and some from the highest courts. Those countries are South Africa, as we've heard. India has some good jurisprudence in this area. Argentina, a civil court of appeals applied the actual malice standard. In Brazil, the Supreme Court threw out cases brought by judges against newspaper and journalists. Colombia, Mexico, in the US, several cases, Canada and Italy, all with positive judgments. Negative judgments from the Supreme Court of Peru and a higher court of Bulgaria, and from Serbia, mixed. So it's a testament to how the database serves as a good collection of information, and also a tribute to contributors that we are focused on the positive cases because we know that there are so many negative cases out there. But a decided trend among all of these cases that I've just mentioned. So we'll move on, and I do want to say that we are moving quickly so that we can hear from the audience both questions and comments. So next we'll move to a discussion of the environment in journalism. Barbara, will you lead us off?
Sure. Hello. Yeah. Thank you very much, and thank you for the invitation. It's wonderful to be here. Yes, so as was mentioned, I have worked on the defense of press freedom, media freedom for many, many years. And recently, after leaving IPI about a year ago, leaving my position as executive director of IPI about a year ago, I specifically dedicated to looking into attacks against environmental journalists. So still press freedom, but with a focus on environmental journalism. I wrote 2 reports about it. The second report is based on interviews, in-depth interviews with approximately 40 journalists from literally from all over the world, from I think was 27 different countries, to understand what are the challenges. And there are a number of challenges, and I just referred to the legal ones for the purpose of today's discussion. So I must say that basically all of them mentioned legal harassment as one of the biggest challenges they face. They also said that the lawsuits they face are very often not even linked to the main subject of their stories, is not linked to the header. Very often they're linked to a small paragraph or a small sentence somewhere. So it is clear that the sole purpose of many of these lawsuits is intimidation, and basically to create a constant sense of pressure, so to induce self-censorship. SLAP is very common, obviously, big problem also for environmental journalists, defamation, but also other types of journalists face also criminal charges, insult. I'll mention later a case of a journalist who is facing terrorism charges, so for covering an environmental story. And so why is this a problem for environmental journalists, or why is this a problem? We understand it, but in analyzing environmental journalism separately, journalists who cover environmental stories, they come up against industries and business where there is a lot of money involved. And this greatly increases the risk of legal harassment. It's just so, for example, a Colombian journalist I spoke to said that their stories on the carbon market. So how do you call it? The carbon. Forgot the name. The carbon are much more are more likely to receive. They're more likely to receive lawsuits for their stories on the carbon market than on, let's say, the mining industry. And this is because there is just so much money. There are international players at stake. There is the risk that exposure of wrongdoing will affect the prices or scare away the government is very big. And that's why, or other journalists in Africa mentioned that stories on green hydrogen are also very likely to be, they were likely to be sued for stories on green hydrogen because there are big public funding linked to the production of green hydrogen and so on. So huge economic interest. And the other thing that came out very strongly from my research is that comparing to other fields of journalism, environmental journalists, there are many of them are freelancers. So they're even more vulnerable. The defense is difficult. Legal defense is difficult. And specifically for the purpose of today's conversation, you know, what is the role of the courts? Many of these cases don't even come in front of the courts because journalists cannot afford to fight them in court. So that's the big problem we see here, that many journalists I spoke to, they said, you know, I cannot afford to be sued, so they will self-censor before anything happens. And that's why Reporter Shield that you mentioned is so important, because they do offer pro bono legal support, and pro bono legal support is so seldom so difficult to find. In some cases, also to show that these cases are really meant as an intimidation, journalists will be sued, and the claimant will just retract, so they will step back just a couple of days before it comes in front of a judge. So they also don't want to go in front of a judge, but it's just meant to scare the journalists. We mentioned insurance. Some journalists recommended taking out legal insurance, not of the type that Reporter Shield offer, but just normal legal insurance. But they said it's also a problem because a lot of the insurance will push you to settle because they don't want to face the legal costs. So they will put pressure on you to actually settle. So journalists said it's so important to actually go to court and be able to fight it. But it means a lot, like costs and a lot of time. So it's that where journalists spend collecting information and also going to a number of trials. Yeah, there is maybe one case that could be interesting, which I just wanted to mention because it feels so absurd, if I have time. Is a Turkish environmental journalist, Hazal Hoçak. She's very well known in Turkey. She focuses on the real estate market and on the environmental consequences of real estate, and also the corruption linked to permission for real estate projects. And so she faces charges of identifying a state official on anti-terror duties as a target. This is linked to an article, to an investigation an article she published about the director of communication in the president's office, Erdogan's office, who has a villa on the Bosphorus, which one of the most beautiful parts of Turkey, one of the most valuable and environmentally protected. He's apparently renting the land on which his villa is for a very, very cheap price from another public officer. And he built a gazebo and the fireplace without permission. So this journalist covered it. And to show this also, she posted a photo of the villa that she took from the street. So it was just walking on the street and took a picture of the villa, and she was accused. So the owner filed a complaint, which led to the charges of identifying a state official on anti-terror duties as target. He's not on anti-terror duties. He is the director of communication of the president's office. And yet, she came to at the first court case. It took 3 years, where she had to go to court many times and spend a lot of money. So she won the first case, but now is going to the next level on appeal. And she doesn't know, because of the uncertainty of the independence of the Turkish court. She doesn't know what will happen. So this is just to show such an absurd accusation and such absurd charges can still be brought against journalists and have this level of chilling effect.
Thank you, Barbara. And interesting your point that many journalists covering environment are independent freelancers, which obviously puts them at greater risk. We're certainly well aware that anyone covering the environment, land use, corruption is subject to heightened risks, both physical safety and of litigation. But they're particularly vulnerable if they're freelancing. And to point out, for lawyers who might be interested in participating in Reporter Shield on the defense side, Reporter Shield both offers pro bono legal defense, but also will pay lawyers. And it does have a startup fund of $9 million to help defray those costs. Aiming for low bono to sort of establish rates that are more or less affordable. So next we'll move to discussion of free expression in elections, hearing from Mishi. Thank you.
Thank you. I was born in India. We always win the numbers game now. India started its general elections. It's going to go on for 6 weeks. We're in the second week already. I was also asked to talk about artificial intelligence in general. And I, like a true lawyer, just quote other people. And OpenAI CEO Sam Altman said AI will probably most likely lead to the end of the world. But in the meantime, there will be great companies. It's like the New Yorker cartoon about environment. We kill the world, but the shareholders made a lot of money. I do want to say one thing. In the 1940s, a journalist asked Claude Shannon, one of the founders of information theory, can machines think? And Shannon said, I compute so. Both his distinction between thinking and computing and their deliberate conflation in his aphorism help us understand the current spectacle around AI. Governments worldwide have moved from a position of we are catching up ignorance to embarking on regulating AI to their own benefits. Since 2016, the first time anyone actually started to pay attention to what misinformation was doing, because now it was impacting the United States. I've said that India and the US are watching the same reality TV show. This is not my statement. I read it on Twitter, again, quoting somebody else. They're watching the same reality TV show. India is just 2 seasons ahead. And even in the misinformation fueled with the use of new tools of generative AI, we are already doing that. So what's happening in the elections now also informs what's going to happen in November. But before I can actually, if I say more about AI, elections, or other fun stuff, I do want to say one thing. This project is very close to my heart. I was here the first time Agnes and Holly started it, so congratulations. But to me, the effect of riot police on free expression seems much more important than all the AI in the world and its impact right now. The globe, once it has internet wrapped around it, the globe becomes a much smaller place. When some students, and I am a Columbia Law School graduate, when some students walk out on a lawn, pitch tents, it suddenly catches the attention of entire globe. And it comes to symbolize power. It forces out the news of a place where millions of people are right now living under bombs and have been wiped out, tens of thousands of lives. Yet for an entire day yesterday and before, the opinion of the Speaker of the House from Louisiana, speaking on the Law Library steps, saying that to the people who were yelling at him and he doesn't like them, for him to say that's not First Amendment and that's not freedom of speech. That to me seems like the single most matter in the globe right now because everybody's watching and we are sitting 300 yards from there. And that's why the global situation right now is winding up talking about exactly this, what's happening down the block here. And it would hardly make sense to ignore it because that's the way internet works. And that's the way information works right now. And because the way internet is to concentrate the attention of the humanity on a small place. This will produce a bunch, of course, of quick takes, some sound bites, and that will become our reality. That is becoming our reality right now. And a person in a democracy like the United States, which has been aspirational for several of us, that's why we're talking about free expression and First Amendment and global situation, for a person in that country which has the Constitution with First Amendment in it, for that person to stand and demand that the army should be used against peaceful students having a demonstration involving tents and dancing, and the mind of the human race is directed to those people, that's what we have done now. We have wrapped the nervous system of our species. We gave ourselves these whole new set of unusual behaviors. And that's what internet has done, that's what social media has done. And AI has already been a big part of it. The news feed which we have been seeing on social media, which has led to misinformation, disinformation, is not new. It's not ChatGPT. This had already existed for us for a long time. And the mass hallucination that AI produces in this nervous system forces us all to talk about the political situation as it impacts the globe. That's why the project is called Global Free Expression and why it is interrelated. So to my mind, when I do talk about AI all the time, there is no AI exception to the law, although Sam Altman likes that. That's why we see this urge to force people to say, don't look here, talk about generative AI, talk about the biases here, because otherwise the few powers who want that would not want us to pay attention to it. I know that's not what you asked me to talk about. I do think that as a lawyer, the important thing is, of course, the cases which are in front of us. Copyright infringement, a big one already going on, scraping of data from internet, which is used to train the large data sets, a very big issue. Open source versus closed source, again, a very big issue. To your point, a lot of money is behind it, and that's why we are seeing such division of it. And the most important one, the lost in this excited talk of regulating AI is the core issue whether governments and companies, they have unfettered right to the billions of data points about us, which is being daily mined, and then to make these training materials. So these legal issues, we will fight them. None of them are going to be simple or easier. You've seen a list of various lawsuits that are pending, whether it's the New York Times one against OpenAI, or it is about various authors guilds who have filed against these companies, or starting with comedians. We also have one interesting lawsuit in Georgia, which is about defamation of ChatGPT. But to my mind, right now, all of these lawsuits are going to travel very slowly through our system. However, facts are being created on the ground, and all whether it is the politicians or the companies, they are very much interested in the regulatory debate before we can actually get into the law. Law takes time. We perhaps don't even need the same kind of laws as they are forcing us to think about, but the entire discussion seems to be much more about a red herring than to say this is what AI is doing to us. I will stop and let others talk.
Well, thank you, Mishi, and thank you for pointing out to us in the country with the First Amendment how much is needed in terms of internal education of our populace as well as our congressional members and other government leaders, which is a serious point that bringing litigation has one impact, but that as courts have even less impact and less independence than they may have had in prior years, say in the golden years of the 90s, the 80s, that there needs to be more effort in public education, public communication. We'll come back perhaps to some questions about elections, but I want to move to Jorge. And as I mentioned, he is an independent expert for the UN Harmony with Nature program established by the General Assembly 10 years ago in 2012. 2009. So please do tell us a bit more about that program as well as about your work with the program and with Mishi.
Well, thank you very much. As Sandra mentioned, I'm from Mexico, and mostly of my work has been developed in Latin America. And that's why I prepared, in order to fit the time, I prepared some words in order to share with you that experience and in this perspective of environment and journalists. So thank you all for this opportunity to discuss the crucial role of environmental journalists in the Americas and the pressing need to protect them as human rights defenders. Thus far, there isn't a specific case as concerning environmental journalists within the Inter-American system. However, we can identify important standards that could provide coverage for them. Let's begin by recognizing that journalists are protected by Article 13 and 25 of the American Convention on Human Rights, which protect freedom of expression and access to justice, highlighting journalists' fundamental role in keeping society informed and strengthening public discourse. Therefore, it is essential to ensure the protection and the necessary independence to carry out their work effectively, as Professor Bertoni mentioned in the cases Herrero Ulloa and Vélez Restrepo. The Inter-American Court of Human Rights has also emphasized the importance of the procedural rights of access to information on protecting the environment as part of the right to freedom of expression. In essence, it has given a social and collective dimension to these rights, particularly regarding the environment. For instance, in the case of Claude Reyes versus Chile. However, the complementary category of human rights defenders receives additional protection in the Inter-American human rights system. As the Inter-American Court has emphasized, the quality of being a human rights defender arises from the work someone does, regardless of whether they are a private individual or public official, and includes the defense of the environment. If a person is self-identifies as such, they could align to the international definition. Environmental journalists, as Barbara just mentioned, are facing escalating threats and risks. Likewise, the alarming number of murders among environmental defenders in Latin America underscores the urgent need for policies ensuring the protection and safety. The pervasive issue of impunity compounds this challenge. Moreover, the Inter-American Court has highlighted that the lack of due diligence on the part of the states in the face of factual threats to environmental defenders leads to a state responsibility, even if the perpetrators are not state agents, as in the case of Luna Lopez or Caguas versus Honduras. Moreover, in the recent case of Barahona Bray versus Chile, where an environmental defender was convicted of defamation against a senator in a type of slap suit due to his activism against the illegal logging of a legendary tree in his country, the Inter-American Court of Human Rights reiterated the prohibition of using criminal proceedings in such cases as means to silence environmental defenders and the chilling effect that this generates. Furthermore, it is worth noting that Article 9 of the Escazú Agreement is the first instrument of its kind to recognize the rights for environmental defenders, such as the right to life, personal integrity, freedom of opinion and expression, assembly, association, and movement, as well as access to information and justice. It also emphasized that the states must ensure a safe environment for them and prevent and investigate attacks against them. In short, recognizing environmental journalists as defenders of environmental human rights can provide a robust legal framework for their increasing protection, particularly in light of the standards of the Inter-American Human Rights System and the Escazú Agreement. Shifting to another topic, I would like to address the global and particularly Latin American trend in recognizing the right of nature as an autonomous right, separate from environmental rights. This is achieved through granting legal personality to natural entities such as rivers, forests, and lakes, which has significant implication for their conservation and protection through guardianships or independent scientific entities. Among others, the most recent example of this progress is observed in the recognition of the Marañón River in Peru through the fight of a group of many farmers and indigenous women. I have had the opportunity to speak with journalists who have covered these other related topics, and I can attest that many see themselves as defenders of the earth through their press work. They highlight many of the challenges we have discussed at this table, especially in cases related with illegal mining. But they also assert that this type of news of rights of nature doesn't receive enough coverage, especially in mainstream and global media outlets, which generally have greater reach. Therefore, we face a journalistic challenge in terms of coverage, as what is not disseminated loses relevance in today's media landscape. Finally, I would like to point out that this past Monday, April 22, was Earth Day. I hope this serves as a reminder that we all must be part of the solution for our common home. To do so, we must protect freedom of expression in all its dimensions. Thank you very much for your attention.
Thank you, Jorge. Fascinating, and I'm sure that maybe of UNESCO is taking notes about opportunities for expanding some of the journalism training concerning the environment to also understand the full richness of the notion of the rights of nature. I think we lawyers also could use updating as you have done. So Nikolaus, finally, and thank you for bearing with us, for being on the screen. We look forward to hearing now from you about a range of issues concerning AI and freedom of expression. Thank you.
Thank you very much for having me, and my apologies that I couldn't make it to you on site. I'm in Europe at the moment, and it's in the middle of the term, and I couldn't travel. I'm sorry. So thank you. I will be very brief because it's rather exhausting to listen to someone online, but let me just stress several points here from a European perspective. The first one is the situation of journalism in Europe, and when I speak about Europe, I mean the European Union now. So the situation of journalism in the European Union is rather serious at the moment for several reasons. The first one is economic reasons. We are in the middle of a fully blown media crisis when it comes to legacy media all over in Europe because their business model has significantly decreased and lost attraction for readers, so that many very popular media houses are in serious economic trouble. Second, because public broadcasting is politically very seriously in trouble in quite some of the European member states, in particular for reasons of trust or trust issues that people no longer really trust public broadcasting media, and follow arguments that public broadcasters are delivering fake news. Third, because there are some European member states, such as in particular Hungary, who were very successful in also profiting from a government perspective from these tendencies by really putting media houses, almost all media houses, under direct control of the government and of people the government trusts. That's the first point that I want to make. The second point is many of those developments, at least from a European legislator's point of view, have something to do with platforms and digitalization, but in particular platform economies, and therefore with companies which are not run by Europeans or are not really placed in Europe. And different from many other areas of the world, Europe has, in the last years, tried to control this issue more by active legislation. So what Europe has been doing in the last years was to actively develop several important laws. They are normally called acts, which are directly to be applied in all the member states in order to get some of those problems under better control. Before I'm speaking about those acts, I would, however, like to mention a fourth reason why this problem is so serious, because just like in other areas of the world, we are ahead of elections at the moment. There's a European election coming in June, and some of the member states are going to vote also in this year, including my own home country, Austria, having general elections in October. And the European Network Information Security Agency, so that's an official authority of the European Union, published a report on the main security issue, computer security issue of 2024. And according to ENISA, the main security threat in 2024 is manipulation of the elections by, however you want to call it, right? By influencers or by media productions, which are coming which are potentially coming from countries who are not members of the European Union. So it's considered to be a top security threat. It's not just democracy and freedom of speech and all this. It's about security and state security as a top threat. So what happened now was, as I said, that Europe has come up with quite a lot of legislation on this. I would just like to highlight GDPR as being probably the most prominent example and also the most traditional one. GDPR stands for General Data Protection Regulation. This is from 2018 and has tried to get data protection into a better shape here in Europe. And building on this, we now have, in particular, a European Media Freedom Act that is of relevance to this panel. And we have a European Artificial Intelligence Act, which now and we have a Digital Services Act, And those three, I would say, all of them try to get platforms better under control as they are at the moment, in particular when it comes to manipulation of public opinions by deepfakes and fake news. The approach is that the Freedom of Media Act tries to guarantee independence of traditional journalism and traditional journals, both in public broadcasting and in private media. The Digital Services Act tries to extend the obligations of platform providers, and the Artificial Intelligence Act tries to mitigate the risks coming with artificial intelligence in the media, in particular mitigating the risks that come with fake news and manipulation of images and videos. How is this done? It's done by an extensive list of different risk levels that come with artificial intelligence models and systems. And the more risky the system, the more rigid the regulation, and the more rigid public overview about what those systems are doing and are supposed to do. What the European Union is expecting here, and I would be very interested to hear from you whether you would share this view. What the European Union is expecting here is some kind of so-called Brussels effect, which means that the hope here is that other areas of the world would take this as an example or as a positive example, so that artificial intelligence, just like data protection, where Brussels argues that this Brussels effect was already visible, so that other areas of the world, just like in data protection, might follow this approach of a more attentive and closer attention from an ex-ante point of view to be attributed to these developments and the risks coming with these developments. I'm very happy to go deeper in any of the details that you might be interested in, but I would like to close for the moment with this. Thank you.
Well, Nikolaus, thank you very much. It opens up a lot of questions, and it also, sorry, thank you. It, what you talk about demonstrates the interconnectivity of the topics that we're talking about here, including the heightened concerns around election security and election free expression, and the potentials for SLAPP. I wonder, Nikolaus, has there been any particular litigation concerning these EU acts that you could describe as for us as an illustration of how these acts are being implemented?
Yes, for GDPR, not really yet for all the others, because all the others are very recent. They are from 2024. Some of them are not even in force yet. So there are no cases to report yet on those acts. When it comes to GDPR, yes, there are several cases trying to mitigate the risks and coming with rather serious fines also, and in particular against some of the platform providers for violation of data protection rights. And the fines in some cases are somewhere beyond $1.5 billion to each of those companies for infringements of those acts, in particular the GDPR. So the outcome of this is that international platforms have started to take this seriously, simply because of the amount of money they are risking if not following rules.
Thank you. We have now about 30 minutes for questions, and so I look forward to taking some questions. If speakers can identify yourself and get a microphone. And while that's happening, I'm just going to pose a question to Mishi. During our lunch, we talked about elections, and you were very interesting in talking about the current Indian election. There might be questions from the audience, but you also mentioned that of the social media platforms, you felt that the Reddit is being most responsible in terms of content moderation. And I wonder if you could speak a bit about that while we wait for, and I hope that people are getting microphones. Okay.
I also want to say that Reddit is doing a good job because the IPO was coming, but it's not as popular in India as perhaps a WhatsApp or Instagram is. TikTok is already banned in India. Heavens haven't fallen, 3 years going. So, and what we did, that was in response to the skirmishes on the border between India and China. That just tells you how important tech platforms are in geopolitics of today. But to your point, I find it very fascinating that in India, ostensibly a democracy, but mostly an elected authoritarian government for the last 10 years, and maybe again in this election, has found a great way of censorship by proxy. What they do is they use subordinate legislation. This is not actual legislation from the parliament. This is rules that executive comes up with, like an executive order or some other rules an agency will do here. Through that, the idea is whatever the government decides, Facebook, Google, any platform, they should come meet the government every week. They will tell them what needs to be removed from social media, and it gets removed. That's true in 144 handles. In February of this year, farmers were protesting, their handles were removed. Cartoonists, journalists, mainstream media in India has been bought up entirely. So if you turn on television or anything else, or most newspapers, you would rarely see criticism. There is enough of print media still existing, but a lot of journalists have now moved to platforms like YouTube. And it's an interesting thing. I think somebody made a comment earlier, Maria made that comment earlier. And then the idea is that when you're being censored by your own government, social media platforms or tech platforms do offer you that platform for your voice to reach many people and also to make money. However, if the government can also censor, that takes away your right to livelihood as well. And some channels can be taken down as and when they feel like. And that's happening quite a lot already in India. Twitter, after Mr. Musk, has no trust and safety or no content moderation in India. Whatever they tell them, they remove it. They have one case going on about which they had gone and resisted government orders. Now in India, if content is taken down or anything is blocked or your entire channel is taken away, all you get is an email which says, pursuant to the government of India's orders, we are removing all of this. You can pursue your own remedy. That's it. The law requires everybody to maintain confidentiality. The Supreme Court says, oh, if your rights are being violated, go to court. And my question to the Supreme Court was like, and show you what? Because your law says confidentiality. I have one email, and every time I go to a federal court, you tell me that what am I fighting for? So there are no principles of natural justice. There's nothing which is followed. So it's a very nice black hole, censorship by proxy. The government is not censoring it. The companies are private companies. They are not obligated to keep or protect your free speech. And so a lot of people in countries like ours are stuck between the governments who want to censor you, the companies who are first to give away your rights when pushed against the wall. But if you sit in the United States, then obviously these are the defenders of free speech and expression, Twitter or Facebook or whatever. So that's the fun part happening.
Thanks for the sobering statements. So to hear now from the audience. Okay. And of course, identify yourself.
Hello, everyone. I'm Lautaro. I am a legal researcher at Columbia Global Freedom of Expression. Thank you for your dissertation. It was illuminating. I want to ask maybe Caroline, but all the panel, SLAPS is a novel idea in human rights courts, and I would like to ask the panel how to identify whether a lawsuit for claims of further free speech liabilities are SLAPS. Perhaps the dividing line is difficult to draw in some cases, and of course there could be claims that maybe at first be legitimate. I am thinking, for example, of cases involving women or minorities in public roles who may be offended by hateful or dehumanizing speech. We recently at Colombia had a very important case decided by the Colombian Constitutional Court about defamation. Again, very important politicians, women politicians, activists, and journalists. And well, the court recognized the right of this group to not be attacked in digital platforms and the public discourse. But on the other hand, you are maybe familiar with the case of Palacio Urrutia versus Ecuador, in which the Inter-American Court decided last year for the first time that a defamation case made by the former president, Rafael Correa, for $1 million for a defamation made by a journalist was a sort of slap case. So how to draw the line between which is legitimate and which is not?
So are there other questions to take at the same time? So Vak, can please add your question.
Hi, my name is Bak Janaf. I'm a human rights advocate with Amnesty International. So quite a lot of human rights NGOs came out criticizing, pretty much saying that there are forms of artificial intelligence needs to be banned when it's used for facial recognition, when it's used for autonomous weapons, whatnot. I'm just wondering, do you think there are forms of artificial intelligence, any type, generative or any other forms, that you think are on its face will always be undermining freedom of expression and it should be prohibited just like outright because regulation just will never catch up with it?
Okay, thank you.
Thank you.
And a third question up here in the front, and then I'll turn to the panelists.
Thank you. My name is Enrico Wilford. I'm a journalist from Guyana in South America. I'm concerned, and I would like to know from the audience whether there is concern that this thing that we call the internet is not really controllable at a point in the future, in that we seem to be concerned only about content rather than the carriers, rather than the people who control the platforms on which these things happen. To me, it's like a train and a train line. We all connect to the train line, the signals are all there, and so on, but we're more concerned about the locomotives and the things that are being pulled. What happens when the train lines are directed and pulled and the signals are changed?
Well, that's a fundamental and poetic question. Three questions. How do we tell when a defamation or other similar case is abusive and therefore can be categorized as slap? Bach was asking about AI, including generative AI, when it can be consistent with FOE, and I think a question Bach was regulate. Do we always need to regulate? Do we always need to regulate? And our third question from the Ghana journalist, which was well stated. I just couldn't consolidate that question. Responding to the slap question, Caroline.
Thanks so much, and thanks, Lautaro, for an interesting question. I think it isn't always easy to identify when there is a slap. There are some characteristics that have been identified by courts. Many of them involve the amount of damages that are sought, whether that's astronomically high or zero, because often powerful people are seeking only an apology because the money doesn't really matter. Other elements are when the merits are just so weak that, an example, of when someone will bring a defamation case and then a week before it comes to court, pull out, as Barbara mentioned. So there are those characteristics, but I think what was also so beneficial from the South African cases was how they characterized all three, so all the different things, as an abusive process. And I think that that was powerful in that it was an easy way to identify that it was a slap because it was abusive of the court's process. But what's also really key about that is that the court took it as an offense to them, and it was an offense to the principles of legal procedure and court practice. And that's more powerful than just relying on a freedom of expression defense. Because if you're only seeing the slap cases as being against activists or journalists in the exercise of their freedom of expression, you're then at a risk of, when the tides turn and freedom of expression isn't as well protected as we are seeing, then the power of slap defenses may weaken. But when the courts are taking it into them as it's you could see some of the judges were really angry that their processes were being abused, and their time, and the whole concept of the need for justice was being abused by these rich and powerful and carefree people. And I think that is a very useful way to move forward.
Thanks, Caroline. Jorge, do you have something to add?
Yeah, according what you mentioned, Lautaro, and you cite the Palacio Urrutia case, and that's very interesting because we have an example of a tribunal dealing with these kind of cases. And just to remind, because in the morning it was mentioned, this standard of the tripartite rule, and which is very related with the proportionality test, no? That most of the international tribunal has applied in those cases. No? Just to remember, we have to see if the restriction that will be imposed, for example, for the journalist or for the person who made the statement is legal. What is the aim of that specific restriction, if it's necessary in a democratic society, and if it's proportional. And running that specific test, well, you can see when it's disproportionate, right? So I think that's a tool that has been developed in a judicial system and could be useful to identify those specific restrictions.
Thank you, Jorge. Nikolaus, would you like to address the AI question?
Sure. So the answer to this is yes. The European legislator sees specific cases which are to be prohibited from the very beginning, so they should not be introduced. This is not so much argued for with freedom of expression, but more with right to privacy, right to data protection, and human dignity. And it's, however, as always, the case that the devil is in the detail, because the Artificial Intelligence Act, on the one hand, has a clause making the usage of online video surveillance in real time, that is using AI to identify people, illegal. So the principle is this should not happen. However, as some of the member states' governments were not really happy with this for reasons of, obviously, for reasons of enforcement and crime prevention, we have, I think, 763 words, if I remember the number correctly, 763 words trying to regulate the exemptions from this rule. So there is a rule, there is a principle stating this is not going to happen in Europe, but then there are 763 words making it possible under certain very limited cases. So it needs to be against serious terrorism, there needs to be a court involved, there needs to be a report written and given to the public after each of those events, etc. but there is no clearly, seriously given fundamental. We are not going to accept this in Europe. It's a compromise, and that's true for many of the other cases too. So you will very rarely find a clear statement in the Artificial Intelligence Act that something which has some impact on freedom of expression is ex ante to be illegal. The second part of the question, which is about whether this is something that should be put into a law at all, or whether this is to be solved more on perhaps on a technical level, this goes also a little bit into the area of the third question. The Europeans would argue we like to put such things into laws, and we are very good in writing this into lengthy legal documents. Perhaps also because we do not have sufficient grip on the infrastructure for reasons that are rather obvious. None of the major platforms, none of the major infrastructure providers is a European company.
Thank you. Mishi, did you want to add to that?
I think Nikolaus covered mostly it.
Oh.
The only thing I will say is that real-time facial recognition with biometrics has been used by the Ministry of Home Affairs in India to identify protesters and then gone after them. And although and I like the Brussels effect because the US is never going to do anything, and the GDPR effect is real. So similarly, what Nikolaus mentioned about unacceptable risk, that's what the EU AI Act says. However, refugees, that time there is obviously an exception, because that's how a lot of discussion of law enforcement and security happens. So those are the kind of exceptions which are being discussed many a times wherever the laws are being discussed. This question was very interesting, the third one.
Yes, would you like to address it?
I don't know if you were referring to telecom service providers, because they do have a role, but the platform companies do have a much bigger role. They like to pretend it's all user-generated content. That's why Section 230 is such a big deal in the United States. But we've all somehow bought into the fact that we have to protect platforms, otherwise free speech and expression is going to disappear. Which is not true, because left to their own devices, this is the state where we live, where the state of democracy in the world is where it is, whereas misinformation is all the time happening, and real-time violence happens. But the only thing important is growth of the American platforms. So I think everybody knows it, that the emperor is naked, but it's an American one, so how can you do anything about it?
Barbara, some thoughts.
Maybe adding with regard to the question whether we want to regulate the train or the tracks, and actually a lot of the regulatory framework related to the platform. Some of it looks at the content, obviously, but and very often this is the most problematic aspects of the regulatory framework. But a lot of it looks at how platforms operate. It looks at algorithms, at transparency of the algorithms, it looks at data protection, looks at micro-targeting. Also transparency with regard to the takedowns. And so there is a lot of regulation that does not relate specifically to the content already. And this is, I think, the direction that we are trying to go. And from my point of view, is the right one.
Thank you. So we have time for a few more questions from the audience. And Isa, and also Dave. And may I say, we welcome your comments as well as your questions, if you can keep them brief. And
thank you, Isa Luna from the Latin American Institute here in Colombia. I was just referring to this challenge of enforcing regulation to protect journalism, or human rights defenders and environmental defenders. My question is, would you think it's useful to also work with these defenders and journalists in their risk assessment, and how can we, empower them with better tools to learn about the networks and the criminal networks or the risks that are around them? That's it. Thank you.
Thank you, Lisa. Dave?
I'm Dave Schultz. I'm with the Yale Media Freedom and Information Access Clinic. And I have a question that goes in slightly a different direction, but I'm just curious because Nikolaus mentioned like four problems with journalism in Europe. And the last one had to do with an election coming up. And as I understood his concern, misinformation, particularly misinformation from foreign governments and foreign bad actors interfering with elections. And I'm just curious about what people have done or what people are thinking about. Is there a solution to that that's consistent with freedom of expression? I mean, the problem we have here in the States is there's been lots of examples of interference by the Russian government in the 2016 election, which has been analyzed to great extent. But most of the things that people would say were interference are things that people would also say are clearly protected under the First Amendment if you just look at them as speech. Is there, two questions, I guess. To what extent do we know that it is really a significant problem, our elections being swayed? And two, if it is there a solution that doesn't undermine freedom of expression in ways that are more dangerous than the problem?
Thank you. And Lisa, up here, we have a third question, and then we'll get final responses.
Thank you for a very rich presentation. My name is Itai. I'm Columbia PhD in history and associate professor of human rights history at John Jay College. I have two questions. The first is about the SLAP. I noticed, Caroline, when we talked about the countries, there was concentration. There's common law jurisdictions, there's Latin America, and there's Balkans. I'm wondering if there's a pattern here, and if so, why is it so? Second question is about the AI. When you mentioned tracks and trains, you reminded me, American legal history in the 1870s, there was an expression called the railroad lawyers, the ones who were involved in the transcontinental railroad development, which were essentially corrupt and very difficult for individuals on the road and for the workers. So my question is, from that, perhaps we should, as human rights advocates, ask that both the railroads, both the trains and the tracks will be monitored, because both are as effective and both are part of our daily lives. Thank you.
Okay, thanks, Itai, for that suggestion. So 3 questions, and we have just a little less than 10 minutes to wrap up. So I'll ask each person to comment to the questions that have been asked, and to add any final concluding thoughts, and we'll 1 to 2 minutes each. But maybe just starting, Nikolaus, with you, if you could respond to Dave's question, election interference. How significant is the problem, and what are the solutions that are not going to be detrimental to free expression?
Yeah, thank you very much, Dave. This is, of course, those are excellent questions and very important ones. So to answer this politely, I don't know whether anybody knows how serious this problem is. And of course, it's very much a question of whom you believe in this, in particular, if you have a legal background. I mean, there are rumors out there all over. But to the very best of my knowledge and to the very best of how much I can tell about that, it is indeed a problem in Europe that people try to use illegitimate instruments to manipulate elections, and that some of those attempts are, or many of those attempts even, are steered by foreign governments. So to the very best of my knowledge, the problem is there. How serious it is, I mean, this is, of course, a question of standpoint, but if it's true that the problem is there, that might suffice. When it comes to whether there's any solution to this, Actually, I don't really know. The only thing that I know is, first, what we see at the moment, the AI Act in particular, is in my view, but also the DSA, the Digital Services Act, which deals precisely with platforms and their obligations, is not a solution. It's not a solution for two reasons. First, because it's by far too technical, lengthy, complicated, and gives all kinds of room for interpretation that platforms are very good in using. So that will lead to lengthy proceedings and years of uncertainty. And second, because at least in my reading, the Act does not really draw a proper distinction between expression of opinions and illegal manipulation of elections. So the borderline in between here is not really part of, at least not in a convincing way, part of the law. And the very last short remark, just as an example, we did not really have a problem in Europe in making access to Russia Today illegal. So it's illegal to broadcast Russia Today in Europe based on a European rule at the moment, because the legislator sees Russia Today as an example or an instrument of warfare, and acts accordingly. So we put perhaps freedom of expression here less prominently than the US discussion would do that.
Thank you. So I'll move on to Caroline if you want to address the question about slaps. Are they increasing problems around the world? And sort of how do you see them developing? And I'll kind of throw in also that the one case in the United States categorized as a slap that resulted in a finding that the litigation was not abusive was in the Gawker case to protect privacy. And so how do you see that line of what's private of a public person?
I think I will sort of partly draw on my disclaimer at the beginning that I wouldn't call myself a general slap expert, and so wouldn't want to comment too much on the sort of nature within common and civil law systems and their creativity. But I think your point at the beginning about when you were looking up on the Columbia database to see how many slap cases there were, and that many of them are from the last 3 years, is very indicative of that this is a rising problem. And I think we can predict that that the trend is going to keep going up. The question around privacy is really interesting, and I think that if I were to identify another potential threat, as we're talking about threats to freedom of expression, certainly our experience is in this balance between the right to privacy and the right to freedom of expression, and where the rights intersect. And we certainly are seeing, again, an abuse of certain processes and an abuse of certain principles in using questions around privacy and the protection of often confidential commercial information being used as a way to repress expression, particularly in a journalistic setting. So I think that might be something that we can keep an eye out for the next year or so around how those rights are being balanced. And giving a plug for the database again, look out for the tag around privacy and expression, because I do think that it is something that will become key.
Right, a good suggestion to watch out that space. Thank you, Caroline. Mishi, and if you would like to respond to any of the questions, perhaps to Isa's question, or any final comments.
No, I don't think so. I think everything has been covered. I think Supreme Court is going to decide here in the net choice case a lot of limits of First Amendment and social media platform. But I think we are deceiving ourselves if we think First Amendment, as we've understood so far, or the absolute free speech and expression is not going to be continued to be exploited by platform companies. And And this is something which other countries have perfectly well understood, especially in India and many other countries in the global majority of the world, where the pretense is already leading to a lot of legislation, which only results in more censorship, and companies are complicit in it.
So Jorge, you could respond, or also back to rights of nature. Could you tell us something concrete that the UN program on harmony with nature is working on or has accomplished? That's one. And or two, could you tell us how a remedy would be different if the right violated was a rights of nature versus a right, for instance, of indigenous peoples to their environment?
Thank you very much. Just to mention related with that question, I am convinced that in order to protect environmental journalists, the best legal framework, at least in the Latin America, it will be the human rights defender framework. And that also includes the risk assessment and the remedies and so forth and so on. And regarding the rights of nature, the Harmony with Nature program is always promoting that countries recognize a new paradigm that shift from the anthropocentric view to an ecosystemic view of nature, because we are part of nature. And environment and human rights is anthropocentric, and that's okay, and it has been working very well in humanity, but now we have to shift for a new perspective as we part of nature. So that is happening in many countries in the world, like more than 30 countries in the world have promoted or at least recognized in their constitution or through legal decisions, judicial decisions, this right of nature. And that it has a complete, many different consequences, because you don't have to prove the damage was provoked for a person, no, in their health or in his life, but in the nature in itself. So that perspective, that ecosystemic perspective, protects nature beyond the person. And in terms of remedies or reparations, it is more sustainable, because you don't have to protect the person because it was affected for a contamination, but protects the specific entity. And well, there are many other aspects to cover, but I will close with that idea.
That's perfect. Barbara, final thoughts.
Sure. Maybe I pick up again on the risk assessment. Do I see it? Question. So there are two types of risk assessment for journalists. One is related to safety, physical safety, and the other is relates also to legal harassment. On the physical safety aspect, of course, there are journalists who, or associations of journalists are working very much to support journalists in their in the need to develop risk assessments and protocols and so on. And many believe that this is, although it's not sufficiently widespread yet, also because it's a question of resources, many believe that this is what has been able to keep journalists alive and out of danger in many situations. So it's really absolutely key. It's a question of resources, as everything, as ever so often in journalism. On the legal harassment, the risk assessment is obviously related to, and again, why environmental journalists, in particular many environmental journalists, don't have a legal background, they have a science background. So being able to refer to a lawyer before publishing would limit the risk. Maybe one last thing I add, which relates to the fact that I believe in Colombia, one of the journalists mentioned in Colombia, there is a law that forces claimants to, anybody who wants to put forward a claim, to ask for a correction or a retraction before they can bring a lawsuit. And they felt in Colombia that it's very useful, basically it referred to a self-regulatory system before you can sue. Now, this is difficult to apply in many other countries, in other countries where the self-regulatory mechanisms are not as strong or as independent or as credible. However, obviously it would be very important that courts, judges consider that if a plaintiff is not willing to go through the self-regulatory system before suing, it's a clear indication that this is a slap.
Good point. Thank you, Barbara. Thank you to all of our panelists. Please join me.
Thank you very much. Have a good day.
Thank you. That was an amazing panel, and thank you to the audience for your great questions. We're going to take a brief break now for about a half an hour while we prepare for the Global Freedom of Expression Award ceremony. I encourage you all to stay because we have Elena Kostyachenko here. She's going to give the keynote, and we are going to have an amazing musical performance by Viva Quintana, the Mexican singer. And then afterwards, for all of you who are here in person, we welcome you to a reception downstairs. And to all of our online guests, we hope that you will return at 4 o'clock for the performance. Thank you all very much.